Will the attorneys in 123-451 State of Kansas versus James Willis come forward and settle into their places? I might make a few comments to help explain to those that may be watching online and those in the courtroom audience that don't may not have seen an oral argument before. Explain a little bit about what happens and what the background is. These cases come to us from a trial court level where there have been proceedings trials that occurred there. We get a record, a written record of the questions that are asked of witnesses, the arguments that counsel make, the rulings that the trial judge made. All of those are available to us along with briefs of the parties where, in this case, Mr. Willard and then later Mr. Ballard have argued that the trial court committed errors during the trials of their cases. We have read all of that material and are prepared now to ask some questions of counsel and to engage in some dialogue with them to help us better understand the arguments that they are making. As we do that, we will consult the notes we've made either on our computers or papers that we have in front of us. But even when we're looking at those things, we are actively listening and engaged in the discussions because it really does help us as we make our decision about what the outcome of the case should be. With that explanation, Ms. Patty, thank you for your patience and please come forward.
Again, Kristen Patty for the appellant, James Willis, who was convicted of first-degree murder, premeditated murder, as well as possession of a firearm by a convicted felon. And we're not really contesting that conviction because he stipulated to it. This case the trial was about 2 weeks long, but what it really comes down to is about 4 minutes in time when my client's brother, Dale, had an encounter with the victim, Jewel Carter, outside a bar where a hip hop or rap concert had occurred. And if you review the record, particularly the closing argument of the prosecutor, it comes down to respect or disrespect. I didn't brief this, but I took all the jury trial transcripts and I put them end to end in Acrobat just to see who used the word respect or disrespect. And nobody seems to have used it more times than the prosecutor in his closing argument. As this was briefed, it was that the prosecutor committed error in closing argument by commenting on facts not in evidence or misstating the facts. He argued that James did not act in self-defense and was motivated by disrespect shown to his brother. But the problem is there was an encounter with a car, which, as we know, can be a deadly weapon outside this rap concert, where I think maybe between the two trials, the evidence was inconsistent, but the vehicle may have hit Dale or may have almost hit somebody else.
There's inconsistency there from Dale Willis's trial,
right?
Which the evidence was that the car did strike or almost strike Dale Carter,
right?
And then I think it was verified in this trial that Dale Carter was. Dale Carter, because I'm thinking.
Well, you must be a Chiefs fan.
Yeah. Anyway, Dale Willis was actually inside the club when the incident happened with the car. And I don't know that that matters that much because the altercation took place in the sucker punch, which everyone testified to.
True.
Took place outside with Mr. Willis, Dale Willis, and the victim. So what's wrong with the whole notion of a state having a theory of disrespect or not respect when that encounter happened? I mean, isn't that what that's about?
I guess the prosecution's evidence just came down to only one witness testified a little bit in that regard. And he did say that, so if somebody disrespects you, especially in a public place in front of people that know you, you're expected to do something about it. But I suppose that maybe he didn't use the word retaliate, but it doesn't really impute motive for murder. A retaliation could have been something quite a bit less than that.
Can't the jury infer, though, from that testimony that that's what happened here? I mean, he describes an ethos in this community of folks that's how you respond. And why isn't it a reasonable inference from that evidence to suggest that that was the motive?
Because there was no, there's an awful lot, as you know, in the trial about what happened before the 4 minutes that we're talking about. And maybe something that happened in the club between Dale Willis and Tyrone Brown, right? And yet,
Yeah, there may have been conflicting evidence,
Right.
but is that evidence that the state introduced about the ethos sufficient to infer a motive?
to me, it seems like a red herring. It seems like, and I realize I'm stuck with a little bit the way this was argued, or was briefed, but it seems like they're trying to create a fear in the neighborhood type sentiment here. Which, these guys coming over from 29th and Askew, near the Jackson Curve. I went to Shawnee Mission East, so this club would have been in my high school district. We've, at least in my mind, when I grew up 40 years ago, that's quite a different environment. There's no testimony that Dale and Joel Carter had any encounter inside the club. When a defense witness, Antonio Frazier, talks about disrespect, but it's about Carter making statements about disrespect, not Dale or anyone else. So it seems like it's an overstatement of the evidence. And while I might have argued it a little bit differently, there is inflame the passions of the jury at the bottom of page 16. The other part of it was that the prosecutor in closing argument misstated the law on self-defense. He stated that for the jury to find that the shooting was in self-defense, they had to believe that Carter had a gun.
And I am having trouble as I read that in context of seeing how that's a statement about the law versus the prosecutor really focusing the jury on the facts. That nothing else except that testimony from Willis gives a foundation for self-defense. So what you have to do is factually believe Willis to be able to conclude that there's self-defense. Why is that reading incorrect? And if that reading is correct, isn't that a fair statement, a fair argument to the jury?
Well, the evidence did show that there was at least appeared to have been some other gun, because I think there were both 45 and 32 caliber shell casings found at the scene. I think the 45 was the one that James had. So someone else did have a gun. It's also, it kind of goes back to what we were talking about, the culture of what of people who were at the rap club that night, that people commonly did use guns. I think that there is some testimony that Dale and anybody who'd been inside, at least who had just come out of the club, they would have had to have gone through screening before they got into the club to make sure that they didn't have guns. But if, since Carter had been to his car and had pulled it up, that provides an opportunity for him to acquire a gun.
Your
That's
answers,
all facts. Yeah.
I'm sorry.
All those things you're arguing are facts,
Mhm.
which to me to this being an argument about the facts, not about the law.
And I always hate it when I have to argue facts. It's
Can I put the question slightly differently?
sure.
Is there any evidence at all in the record that a justified act of self-defense could have been predicated on some fact other than a gun?
As I understand it, Joel Carter was revving the engine of the car. I also understand it, he may have been, one place it seems like the car might have been in neutral. I've also seen descriptions that it might have been put in reverse.
So was there testimony that there was a concern or fear that the car was being used as
I
a
don't
deadly
know that
weapon?
anybody testified to that.
Well, you watch the video, it belies that version, doesn't it? I mean, it's a slow moving vehicle that's exiting the parking.
And for, you know, because of when I got this case, I was not able to see the video. But still
You have
somebody,
not seen the video?
but still somebody, I took it over after briefing.
No, I'm not, I'm just,
Okay. You know, just because a car is going in reverse, it doesn't mean that it can't be put forward again. And if I briefed it, I might have tried to do something different with that. The second issue, and I'm getting a little bit short on time, is whether the district court committed reversible error in the instructions in the jury. We've kind of touched on some of this so far. They did not, the jury was not instructed on voluntary manslaughter with imperfect self-defense, which would be if the subjective element is present, but the objective element is not. We would suggest that that was factually appropriate, because James did testify that he was in fear for his safety and believed that Carter had a gun. He did, you know, Carter was very agitated, and he was trying to get Carter to calm down. The scene was chaotic.
help me here with, we are in clearly erroneous standard of review. How do you clear that hurdle? Why is this clearly erroneous in your view? Given the nature of the case and the evidence?
Because there was testimony to support that either self-defense or defense of others.
From the defendant, James Willis.
Yes. And
That's what your argument would be, that his testimony maybe would allow for the instruction, but in clearly erroneous, there was
well,
a strong.
and certainly, we couldn't argue it, I don't think, without his testimony. There's just the other circumstances, the other witnesses testifying about Carter being aggressive, saying, what was it, Namich, I'm gonna get them, something like that. There's other evidence, but certainly, yes, James actually testifying that he was in here fear for his safety and believed that Carter had a gun, provides some basis for the voluntary manslaughter instruction. And then we also argue that the involuntary manslaughter, imperfect self-defense, was appropriate, because it was, the force obvious would seem to be excessive. And I'm
How do you get around the KSA 225226C, which talks about provocation, who initially provokes any use of force against such person? That defense is not available, or that instruction. How do you get around that when it was Dale Willis who provoked the entire incident?
Well, and I guess it would seem like there was also some testimony that Carter was provoking things with his behavior, his aggressive attitude, his intoxication level that evening. So there are no further questions.
Thank you.
Thank you.
Mr. Gonkowski.
Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas. Gerald Carter was shot and killed by James Willis as Carter sought to retreat from what was at most a verbal altercation in the early morning hours in front of a bar in Shawnee, Kansas. The state reasonably argued that Willis shot and killed Carter over a showing of disrespect by Carter. Carter was inebriated, and the two shared words, angry words, out on the sidewalk that morning. And Carter then, after exchanging words, Carter was punched in the back of the head by Mr. Willis's co-defendant, his brother, Dale Willis. And he was dropped to the ground, and he stumbled back up, and he stumbled back into his car, and then sought to retreat from the altercation. And when he did so, he started the car, and as the court is already aware, the car can be seen on video slowly rolling back from its parking spot. The video doesn't show the perspective quite as well, but it's a fairly steep hill in the parking lot down from the sidewalk. And to the extent that a couple of witnesses testified to the engine revving, other witnesses indicated they believed that Mr. Carter was inebriated and he had put the car in not reverse, but in neutral. And he was trying to get away from the altercation and was applying the gas pedal and revving the engine when the car was simply rolling down the hill in neutral. While the car was rolling down that hill, James Willis responded by pursuing Mr. Carter, pursuing that car, the car that contained what he described from the witness stand as a threat to him. But instead of the way Mr. Willis responded to that threat was to charge toward it and unload 11 rounds from his .45 into Carter's car and into Carter himself. The state's argument that that killing was premised upon a showing of disrespect by Mr. Carter to Willis and his cohorts there that night was a reasonable inference from the evidence. There was abundant evidence from both state's witnesses and defense witnesses that there was disrespect exchanged that night, and that disrespect is not taken lightly in the community that gathered there at the club that night. Mr. Willis received a fair trial by a jury of his peers who were instructed both on first-degree and second-degree murder. And a conviction of the former, the first-degree murder, essentially invalidates the need for any instructions on lessers, such as voluntary or involuntary manslaughter here. I welcome the court's questions to either of those issues, be it the prosecutorial error or the instruction.
I have one question, but it's about the video, and
Yes.
you've seen the video, right?
Yes.
Okay, so where does, I'm going to call him by his first name because he has the same name as his brother, but where is James coming from? He's not coming from I couldn't really,
Right.
I watched it like 4 times, but is he coming from a car that's parked? You know, if this was the sidewalk and he was, you know, there's parking right here. Was he coming from a car over here?
When he's seen on the video pursuing Carter's
Right.
car, I believe so. His truck, I believe, had parked around the corner, 90 degrees to the sidewalk, if I recall.
Oh, okay.
And he had stepped out of that truck at some point and was down there in that area.
But he was never on the sidewalk, right?
As far as I'm aware,
Yeah,
he
so
he
they're
was
having,
further back.
right. and-
away from the camera,
Okay,
right, in the distance.
right. I could, that's,
But
okay.
there are so many things that I wish were more clear in that video, but that's one of them.
Okay, thank you.
You're welcome. The showing of disrespect that the state argued was the motive for this killing. That argument was premised on abundant evidence that came from the form of Demetrius Parker, for instance. Demetrius Parker testified that whenever he's at the club, he keeps his head on a swivel because people start fights over nothing. He testified that respect is not given, it is demanded, you take it. That's from volume 27 of the trial. Antonio Frazier similarly testified that when there is disrespect shown among members of this community, they handle it right then. And he testified, people at the club, quote, don't tolerate it. If someone disrespects, they are going to deal with it accordingly. That's from volume 30. Raekwon Robinson similarly testified that he witnessed the verbal altercation between Mr. Willis and Mr. Carter, and he saw Dale Willis sucker punch Mr. Carter out there on the sidewalk. And that's when Raekwon Robinson decided to leave because he knew the place was getting too tense. Several of the witnesses actually testified to leaving during this altercation because they were concerned about their safety. Tyrone Brown similarly testified he felt there was no point in sticking around at the club because most of the time, the way he testified, most of the time dudes get harder when they got that group. So the testimony was abundant that as tensions flared at the club that night, there were many people that were concerned about their safety, and there were many people that left because of that. And so the state's argument that Mr. Willis shot and killed Mr. Carter over a showing of disrespect was a reasonable inference. It was not impermissible inference stacking, as Mr. Willis argues now, because if you follow the sequence of events, you can see all of the facts that line up to this motive. Mr. Carter was inebriated. The testimony is that he was mouthing off to other people at the club, including Mr. Willis and his cohorts. That verbal altercation escalated when they were out on the sidewalk. When you put that in the perspective of all the testimony about disrespect not being tolerated, then when you see Mr. Dale Willis sucker punch Mr. Carter to the ground, and then Mr. Carter attempt to retreat, a reasonable inference is drawn from all of that the killing was done because Mr. Carter had shown James Willis's brother Dale disrespect that morning. This was not about inflaming the passions of the jury. It was about showing what the actual motive of the killing was. The state's use of the word crew to describe Mr. Willis and his cohorts there was not impermissible. It was not inflammatory. It was not unduly prejudicial, as Mr. Willis now claims. Crew is a relatively bland term. Of all the terms that could have applied here, it's not a loaded term like gang or cohorts or accomplices or co-defendants, as Dale Willis was to Mr. James Willis. And the state pointed out that the witnesses that testified on behalf of Mr. Willis that were part of his group, they all testified one way about the interactions. And that one way that they testified differed from the state's witnesses who were both cohorts, friends of Mr. Carter, and were others that were at the club that night that had no affiliation with either Mr. Carter or Willis. So that's why that argument was reasonable. Similarly, the state's argument on self-defense was very reasonable when put in the perspective of the entirety of the case.
Let me ask you about that.
Yes.
The one thing I'm hung up on is the closing argument. And the prosecutor saying that the defendant, that the jury had to believe the defendant over everyone else.
Yes.
That the victim had a gun. That isn't the law, right?
That's not the law, but that's not a statement of the law. As was pointed out in my colleague's argument, that was a statement about the facts, because Mr. Willis, when he pursued a self-defense theory of this case, it was premised entirely upon his testimony that he believed Mr. Carter had a gun that morning. No other witness testified about Mr. Carter having a gun. The car was searched. His person was searched after he was killed. No gun was found. No casings were found in his car that would have come from his gun. Only fragments and casings from Mr. Willis's gun.
But the argument is that it's the belief, not the fact that he actually possessed a gun, but the defendant's belief.
Right.
And isn't that where the problem lies in the statement?
I believe if you parse the words of the state carefully, it still didn't infringe upon the defendant's right to present the defense that he did. Because the way the state argued it was, in order to find for Mr. Willis and support his theory of the case and find self-defense applicable here, quote, you have to believe James Willis over everyone else that Jurel had a gun. And so the state's argument was, you have to find some credibility to Mr. Willis's testimony that he believed there was a gun there that morning. You would have to give credence to Mr. Willis's testimony to grant him self-defense. And here is all of the testimony on the other side of the coin that shows he didn't have a gun. And that the state's effort there was to effectively impeach Mr. Willis's testimony that he believed there was a gun. The state was refuting that. And the state also pointed out in the same sequence that Mr. Willis himself testified inconsistently about the presence of a gun, because he first testified that he pulled out his gun and fired on Mr. Carter after he heard shots fired. And then later on cross-examination, Mr. Willis testified he realized he better pull out his gun and shoot before Mr. Carter could pull out his. And so the state was highlighting these distinctions between Mr. Willis's own testimony, internally inconsistent, and also the inconsistencies between Mr. Willis's testimony and that of everyone else about the presence of a gun with Mr. Carter. And the state highlighted those inconsistencies in an effort to show that Mr. Willis's testimony that he believed there was a gun in Mr. Carter's possession is not credible, and that they should discount his testimony to that effect. Not that they should ignore it, but that they should discount it and find it not credible in the face of the overwhelming evidence to the contrary. And so that's why the state's argument on self-defense, I believe, was proper.
Could you get to the voluntary manslaughter instruction and on appeal? Why isn't it factually appropriate? Given how we have a sufficiency test that we apply, and given the defendant's statement, isn't that enough to get it factually appropriate?
I believe that's a very, very close question, whether or not it's factually appropriate. In this case, when all we have is the defendant's self-serving testimony and nothing else.
You've seen the cases, that's enough, isn't it?
It can be. And this court has also likewise said that a defendant's statement of his intent from the witness stand may not be enough to factually support an instruction on his preferred theory. The case to that effect was Calderon from 2000, wherein a defendant's self-serving statement of intent itself did not necessarily invoke a duty on the district court to instruct on a lesser form that carried recklessness.
That sort of predates our shift in how we have assessed factual appropriateness, though, right? To where it's more of a sufficiency.
It does appear to be more of a sufficiency case now. That's true. I don't believe as though this court has ever really overruled Calderon to that effect, or explicitly stated that Calderon is no longer good law to that line. But to the same extent that the self-serving statements here should not be enough, especially when they're so conflicted against all the other evidence. As I pointed out in the state's brief, the skip rule also applies to show how inapplicable this would be here, because the jury was instructed on both first degree and second degree. They did not opt for second degree. They did not opt for intentional killing lacking premeditation. They opted for a premeditated killing. And when the jury opted such, that essentially invalidates or it declares immaterial whether or not the district court instructed on still further lessers below second degree. And so this court simply cannot be firmly convinced that a jury would have checked the box for voluntary or involuntary manslaughter in this case, given that they were given an option between two higher level charges and they chose the highest one available. There's no reasonable way to read the jury's verdict that they would have stepped down to voluntary or involuntary manslaughter here. When, as I stated, the Cook case from 2008 talks about when the jury is instructed on first degree, then the correctness of instructions on voluntary or involuntary manslaughter effectively becomes immaterial. Willis's subjective belief about the presence of a gun was simply not credible. Internally, it was inconsistent, as the state has already pointed. And on the involuntary manslaughter instruction that was raised on my colleague's argument just a few minutes ago, at most, Carter was engaged in a verbal altercation with Mr. Willis. At most.
With Dale.
I'm sorry?
With Dale.
With Dale, correct. With Dale Willis up on the curb before James approached. But that verbal altercation does not justify the use by James Willis of any amount of force, much less deadly force. And so even if one believes that Carter antagonized Dale Willis and shouted whatever he did at him, That still does not justify James Willis's use of any amount of force. And as the Justice Rosa already pointed out, under 225226, self-defense is not available to one who initially provokes force, initially provokes the altercation. And that's effectively what Dale Willis, the co-defendant of James Willis here, did that morning when he sucker punched Carter right before Carter attempted to retreat. There was an abundance of premeditation in this case. It goes back into the hour before the killing when the text went out from Dale Willis at the club saying, "Emergency, bro, need you here," and prompted James Willis to text and call all of his friends, letting them know an emergency existed at the club and he needed to get there effectively to protect his brother. Recognizing I'm out of time, I'm happy to stand for any further questions by this court. Absent those, I'm asking that this court affirm Mr. Willis's convictions and sentence.
I see no questions. Thank you.
Thank you.
Ms. Patty, you reserved 3 minutes.
And unless there are any further questions for me, I'll yield.
I don't see any. Thank you.
Thank you.
Thank you to both counsel for your arguments this morning. The court will take this under advisement